This is Right to Life Radio. And now, here's your host, John Gerardi.
Well, it's the 2-year anniversary of the Dobbs decision in which the Supreme Court overturned Roe v. Wade. And I think it would be an opportune time to talk about it. What it is, what it meant, what the Dobbs decision meant, how it is shaping the political and cultural landscape surrounding abortion right now, how things have changed since 2022, for better and for worse, really. I think Dobbs is unequivocally good. And to talk about maybe some of the critiques from some more liberal identifying pro-life friends, who some of whom are trying to make actually Dobbs has been a bad thing and things like that, whereas I think it was unequivocally a good thing. With me to discuss all this, the CEO of California Family Council, my good buddy, Mr. Jonathan Keller, is here.
Hey.
How are you doing, Jonathan?
That is me. I am, true confession, I'm a little jet lagged. I'm a little tired. I got back from Sacramento or from Washington, D.C. after being there for the weekend. And I've realized something, that when you don't just go to a conference, but when you go stand out in 95 degree weather and 85% humidity,
85% humidity,
on the steps of the Lincoln Memorial, your body gets tired from doing that. So
yeah, it's also this thing called getting old.
Yes.
So
yes.
that is also probably not in your favor. It's not in my favor either. But,
I shared an Instagram story a couple days ago that it said, "Man, I would do anything to get 8 hours of sleep. How about going to bed 8 hours before you need to get up?" Well, no, I won't do that.
Yeah.
That's basically our lives.
Yes, there you go. All righty. So, Jonathan, let's talk about the Dobbs decision and kind of the massive impact of it. And you can't really talk about Dobbs without setting the table by talking about Roe v. Wade and Planned Parenthood versus Casey.
Yep.
All right. So
51 years ago.
Yes, 51 years ago. So prior to 1973, abortion was regulated kind of on a state-by-state basis. And pretty much every state in the union had laws on the books outlawing abortion. And most states passed these laws around the time of the Civil War. Because in the 19th century, people figured out, by seeing this stuff done with animal cells under microscope, when you take an egg cell and a sperm cell and you put them together, that is the first cell of a new human organism. That is when human life, a new animal organism, a new mammal organism anyway, that is when a mammal's life begins, when an egg cell from mom and a sperm cell from dad meet, and it forms the first new cell, a zygote, that constitutes a new, unique organism. So that was a huge discovery in the 19th century, and it led to a greater sort of public, broad realization that, hey, when we're discussing the question of abortion, it's not merely a question of, it's not really like a late form of contraception or something. No, this is an actual living human organism that is being destroyed. And so all these states around the time of the Civil War and onward passed laws outlawing abortion except to save the mother's life. And then we get to Roe v. Wade in 1973. So with Roe, you basically had feminist activists in the United States and Great Britain who were developing these theories that in order for women to genuinely be free and equal to men in society, they had to be able to walk away from the burden of pregnancy with the same ease, to be as unburdened by a pregnancy as a man is.
Yes.
And this was the theory of a lot of feminist philosophers, kind of Betty Friedan and people like that, going off of sort of the girl boss version of Jean-Jacques Rousseau, and the idea of human beings being these radical individuals, not characterized, not identified by their ties of the ties of family and other connections that are at the core, I think, of the human experience.
So, John, on that note, I just want to point out something. I saw this fascinating, I think it was on Twitter, but it was someone who pointed out that it's really, really kind of an interesting coinkydink that most of the most revolutionary social thinkers of the last, 200 plus years, since the Enlightenment to now, whether you're talking about Rousseau or Marx,
Voltaire,
most of them either were childless or, like in the case of Rousseau, they just abandoned their children. And they literally said, yeah, we're going to, these individual young humans who kind of get in the way of my philosophy of radical autonomy, they kind of complicate my utopian vision of society. So we should either give them over to the state and have the state run them, or we should unencumber parents or unencumber people from having to be parents.
Right. And that's a brilliant point. Thank you for reiterating it, Jonathan. Because and it is also the thing with modern philosophy, it's this huge shift from, I wouldn't say collectivism, but that human nature has to do in large part with the bonds and ties that we have with each other. That Aristotle's famous quote, that man is a political animal. And what he meant was not that human beings by nature love to watch Fox News. What he meant was that human beings are political animals. They're supposed to live in a polis. They're supposed to live in a society and have ties to each other. Ties to each other of friendship and interaction and love and respect and marriage and family. And that's all natural to who we are as human beings, and that our ethics and our politics and all that should surround that idea of human beings as social, whereas modern Enlightenment philosophy was very much into the idea of human beings as radical autonomous individuals, and that's what's important, is you as a radical autonomous individual. And if you're not the kind of human person that can engage in these radical autonomous things like thought, like abstract reasoning and stuff, like all this stuff that an unborn baby can't do, necessarily you're less important. Anyway, so we've gotten wildly off track already. Basically, you had this feminist push in America and Great Britain and other countries that women needed to, in order to have this radical individualist conception for women, to have that apply to women, that women needed to be untrammeled by the burdens of pregnancy, sort of in a way analogous to how men were. And the only way to do that was through birth control and abortion. So you had this push in England to legalize abortion through an act of parliament in the 1960s. And abortion activists in America were trying to think, how can we legalize it in America? Well, we had seen basically feminist forces legalizing contraception by arguing in courts and getting it all the way to the U.S. Supreme Court that actually the U.S. Constitution itself protects the right of couples to make private individual decisions of what they do in their bedrooms and whether or not they use contraception. That had been decided in a previous Supreme Court case from the 1960s. And so the thought was, maybe we can do this same tactic for abortion, and that's precisely what they did, and that's precisely what happened. So lawyers in Texas filed a lawsuit challenging Texas's abortion statute. The state of Texas had a law in the books saying no abortion except to save the life of the mom. They found a woman who wanted to have an abortion, filed a lawsuit against, I think it was against the district attorney in the county in Texas where this woman lived. The decision goes all the way up to the U.S. Supreme Court, and the U.S. Supreme Court rules in 1973 its decision, Roe versus Wade. And in this decision, the Supreme Court held that there was a fundamental constitutional right to abortion, that hidden in the Constitution itself. And the court didn't seem to think, it was not a very analytically rigorous decision. The court didn't really 100% specify like what part of the Constitution it was in. They thought, well, it's kind of in the 14th Amendment, kind of in like the 5th Amendment and maybe the 9th Amendment, and a little bit in the first. They were very vague about it, as if it wasn't their job to tell people this is where this right is contained in the Constitution.
So, John, I want to read. It might be the first time that we have read the definition of an astronomical term on the show before.
The penumbra's idea.
Yes. So this is from the Oxford Dictionary. The noun penumbra is a word from astronomy that means the partially shaded outer region of the shadow cast by an opaque object. So it's not the object itself. It's like it's kind of like the fuzzy edge that's like
like
when
you can
see shaded shadow.
Like you can see when you can see a quarter the moon at like it's a quarter phase, but you can kind of sort of see the outline of the rest of it, but it's still in shadow.
Yes, or it's like it's just it's fuzzy. It's not really there, but it's kind of there. And the partial illumination, as in an eclipse, between a perfect shadow on all sides and the full light is another definition. So that is a penumbra. And that's essentially what, famously.
And famously, the Supreme Court was sort of finding these rights in various emanations of penumbras of the Constitution, which was the famous line for one of these Supreme Court cases, trying to find all these new rights that were hidden mysteriously in the 14th Amendment. And often the 14th Amendment was the vehicle for this. The 14th Amendment, which was ratified after the Civil War, and it was one of the 3 constitutional amendments that the North made as a prerequisite for Southern states to rejoin the Union. The North sort of said to the Southern states, you can rejoin the Union, but you got to ratify the 13th Amendment to abolish slavery. Got to ratify the 14th Amendment to make all these slaves into citizens. And you got to ratify the 15th Amendment to let them vote. And part of the 14th Amendment was this thing called the Due Process Clause. It said that no person shall be deprived of life, liberty, or property without due process of law. Now, given the context of the 14th Amendment, I think a lot of people at the time understood that as, oh, okay, what the North is telling the South is, hey, you're going to let all these black people become citizens of your states now, and if you deprive them of their lives, execute them for a capital crime. Mm-hmm. You deprive them of their liberty, throw them in jail. You deprive them of their property, civilly hold them liable or penalize them in some way. You can only do that by following the due process of law, meaning like fair judicial procedures, right? So that's what, and the problem is though that Supreme Court justices in the 20th century took that phrase of the 14th Amendment, and instead of reading there like this is the Constitution emphasizing, hey, we need to have fair judicial processes everywhere, okay? And it was immediately followed by like the Equal Protection Clause and things like that. The Supreme Court in the 20th century would often look at that and say, well, the 14th Amendment is creating a protection for and against the states and applying it against the states. No state shall deprive a person of life, liberty, or property. The federal Constitution is creating a federal protection for liberty that states have to respect. As if this is a new thing. Some new rights have been cooked up by the 14th Amendment when that wasn't really the focus of the 14th Amendment at all. Mm-hmm. So the Supreme Court just starts cooking up rights that are hidden somewhere mystically, magically, without any kind of guiding criteria, somewhere there in the text of the 14th Amendment. They're just hidden in there. And among those rights that the Supreme Court discovered was a right to abortion. So when we return, we're going to continue with the history of Roe and the effect that Roe had, how that was continuing Planned Parenthood versus Casey, and what Dobbs changed. That is next on Right to Life Radio. We are back with Right to Life Radio. It is the 2nd anniversary of the Dobbs decision in which the Supreme Court overturned Roe v. Wade. Jonathan Keller from California Family Council here with me, John Gerardi, to talk about it and to discuss sort of the history of what happened with Roe v. Wade, how Dobbs overturned it all, and what it means. Now, we talked about how the Supreme Court issued Roe v. Wade, and the Supreme Court held in Roe v. Wade that a right to abortion was hidden, present non-explicitly, in the 14th Amendment of the Constitution. That says that perhaps in the 14th Amendment. They gave a couple of options, but the main one that people would focus on was the 14th Amendment, that no person shall be deprived of life, that no state, rather, shall deprive any person of life, liberty, or property without due process of law. And the court found, well, the states are depriving someone of life, liberty, and property without due process of law by not allowing abortion to be legal. And they can't do that. But here's the structure for how they can do it. And the Supreme Court in Roe comes up with this whole complicated 3-trimester structure for when states can regulate abortion and how much, which is all stuff that's not in the Constitution. It's all stuff that the court was just kind of making up. There was no sort of pretext, sort of even pretending by the court that anything they were doing was like trying to draw something out of the Constitution that was actually there. They were making up their rules as they went along.
And to clarify, John, because I know some of this, people might be saying, well, why are we still talking about Roe v. Wade? It's still, aren't we just celebrating the fact that Dobbs overturned it? But I think the key point is that a lot of people, if they're not familiar with the history, they are assuming, oh, well, the current court, it's just a numbers game. It's just might makes right, and whichever party can elect the most Republican justices or Democratic justices, if you just get 5 of the 9 votes, you can impose your will onto the nation at large.
Right.
And what conservatives have said, and what I think they did in the case of the Dobbs decision, was no, and explicitly what Samuel Alito said in his opinion was, no, we're not imposing our will. We are actually, to quote from the Dobbs decision, we are returning the right to the people and their elected representatives.
Right, and there is some effort being made to say, well, is this actually a thing the Constitution was protecting?
Is it our personal opinion?
Not is this something that we can kind of read into it because we vaguely sort of have some sense that this is a private thing and the Constitution kind of protects private things, which was about the extent of the analytical rigor of the court in Roe v. Wade. Which, by the way, if you're saying this, John Gerardi is just a right-wing hack, Ruth Bader Ginsburg agreed that the analytical reasoning in Roe v. Wade was really weak. A lot of liberal jurists liked the final end result of Roe v. Wade, but didn't really agree with the reasoning of how it got there. So this is hardly us going out on a limb. The only person today who still thinks that Roe v. Wade is like crystal clear legal reasoning is Joe Biden.
We gotta go back to Roe versus Wade.
Gotta restore Roe, which even other abortion activists are sort of cringing when he says that, because they don't want to restore Roe. They want something more aggressive than Roe. Anyway, what was the net effect of Roe? I think this is the point that not everyone fully comprehends, but it was the essential reason why it had to be overturned. So the idea of Roe is that it found a right to abortion in the 14th Amendment, in this part of the Constitution that said, no state shall deprive any person of life, liberty, or property. The 14th Amendment was applying rules that state governments had to follow as a mandate of the U.S. Constitution. What this effectively meant was individual states could no longer regulate abortion at all. They had to have abortion be legal according to the exact parameters demanded and defined by the court in Roe.
And John, on that point, I actually, someone on Twitter, one of the guys I follow, Denny Burke, who's a pastor and a professor at Boyce College with the Southern Baptist Theological Seminary, he retweeted this clip of Walter Cronkite. It was I think CBS News is where Walter Cronkite was from.
Was this in between lying about how the Vietnam War was going?
Yes.
Okay.
Exactly.
Let's Anyway, so Walter Cronkite.
It was the news report from the evening of January 22nd, 1973.
Okay.
It's a color clip, and it's this 4-minute segment, and they interview people, and it is amazing to go back in the little time capsule and watch that little clip to see, at the time they said, this is what the decision does. Justice Blackmun has said that we're setting up this trimester system and everything else, and it's essentially saying now states may not regulate abortion. We're telling you can't do it in the first trimester at all. You can sort of do it a little bit maybe in the second trimester, and after the 7th month, I suppose you can regulate it to protect the life of the fetus, as long as it doesn't impinge on the health of the mother.
Right. Now, let's talk about this trimester-based system that Roe came up with. as Jonathan was saying, and as Walter Cronkite was explaining, but not giving the whole scoop, Roe allowed states to regulate abortion in no way, shape, or form for the first trimester, maybe to pass some health and safety restrictions in the second trimester, and to ban abortion in the third trimester, but only if the mother's, unless the mother's health was threatened. Now, on the same day of January 22nd, 1973, the court released Doe versus Bolton. And in Doe versus Bolton, the court defined what it meant for a pregnancy to threaten the mom's health. And what they said was, effectively, every unwanted pregnancy impacts the mother's health sufficiently to justify an abortion. If it affects their familial health, if their financial health. So the category was so broad that it was an exception that swallowed the rule. Every pregnancy implicates maternal health. So effectively, at the end of the day, what it meant was no state could outright ban abortion for any portion of the pregnancy. It had to be legal for all 9 months and for any reason, effectively. And that's what people don't understand. I think people still today think of Roe v. Wade like it was some kind of a moderate thing. And it just wasn't.
Right.
It imposed the most. You cannot get a body of abortion law. Should abortion be legal or not? Maybe legal for some portion, not for other portions of the. You cannot get more extreme than it has to be legal for all 9 months for any reason.
Right.
And that standard, with some revision, continued after the 1991 Supreme Court decision, Planned Parenthood versus Casey. Or 1991 or 1992? 92. Court in Planned Parenthood versus Casey kind of changed the rationale underlying legal abortion, and it was Justice Kennedy saying, Justice Kennedy and Justice Souter and Justice Sandra Day O'Connor basically giving the controlling opinion and effectively saying, well, there's some regulations you could do around abortion, but you can't ban abortion as such. You can't limit abortion at all before fetal viability, but after viability, you can maybe regulate abortion unless the mom's health is threatened. And again, it was that health thing.
Yes.
All right. So that was the state of things. It wasn't just that abortion was legal. It was that states could not restrict abortion at all. Even like third trimester abortions, states could not restrict. So when we return, we're going to talk about the Dobbs decision itself, what it has opened up, and the political territory that it has laid out for us. That is next on Right to Life Radio. We are back with Right to Life Radio. We just had the second anniversary of the Dobbs decision on June 24th, this past June 24th, and so we are here to talk about it, Jonathan Keller and I. All right, so we laid the table, Jonathan. Let's serve the main course here. So we laid the table. Roe v. Wade came down in 1973, and what it did was it mandated that every state has to have legal abortion for all 9 months of pregnancy for any reason. Planned Parenthood versus Casey came around in 1992, sort of Roe's successor case. And it said, yeah, you can regulate some things around abortion. Like you can require parental notification or parental consent before an abortion. You can have certain kinds of health and safety restrictions around abortion, but you still have to have abortion as such be legal for all 9 months of pregnancy for any reason. And what happened afterwards for the Supreme Court was you had the standard that Justice Kennedy put in place for when people could put certain restrictions around certain aspects of abortion was, well, as long as it doesn't cause an undue burden on a woman's right to access abortion, on a woman's right to abortion. Which, what is an undue burden? Nobody knew. It was sort of something that this was a point that Antonin Scalia talked about at length in his dissent from Planned Parenthood versus Casey. What is an undue burden? Seems like a whole new standard that we've come up with here. I guess, and ultimately, Jonathan, I think you'll agree, what happened is a burden was undue when Justice Kennedy thought it was undue, it was due when Justice Kennedy thought it was due, and it was really for about 30 years, from about 1992 to 2022, we had this game where basically any abortion regulation that was proposed it was decided on the basis of whether Sandra Day O'Connor and then ultimately just Anthony Kennedy liked it or not. So if Sandra Day O'Connor didn't like an abortion restriction, it didn't go through. And eventually Anthony Kennedy was that decider. If Anthony Kennedy liked it, it was fine. If he didn't like it, it wasn't fine.
That seems like a great standard and method for determining what is constitutional for 350 million people is the capricious whims of one aging former California judge.
Yeah, kind of like an absolute monarchy.
Yeah.
But more based on whether or not you graduated from Stanford Law School or wherever he went. Did he go to Stanford Law School? I can't remember.
So.
Okay, anyway, we can look that up. Look that up in the break. I feel like Joe Rogan yelling, Jamie, look that up. All right. That's a joke that like 5 people will get. Okay.
That's right.
Producer Colton's laughing. So, the Dobbs case, Donald Trump institutes this massive change on the Supreme Court where we go from a Supreme Court with only, 3 Republican appointees and what was the makeup of the court when Donald Trump got elected? So you had 4 conservative. Well, yeah, you had like really 4 conservatives. What was the makeup of the court when after Scalia died?
It was basically 3,
you
1,
had Alito,
and 4.
Yeah, 3, 1, and 4. Okay, yeah. So you had 3 conservatives: Roberts, Alito, and Thomas.
Yep. Justice
Scalia had died. And you had 4 liberals.
Right. You had Ruth Bader Ginsburg. You had...
At 5, well, 4 liberals plus Anthony Kennedy.
Right.
There we go. Right. Okay, so 4 liberals, Anthony Kennedy, John Roberts, Sam Alito, Clarence Thomas, and Scalia was dead. So Donald Trump takes this 3-1-4 court, and by the time he is done with his term of office in January of 2021, the Supreme Court has 6 Republican appointees and only 3 Democrat appointees: John Roberts, Alito, Clarence Thomas, and 3 new Trump appointees: Gorsuch, Kavanaugh, Barrett. A case gets brought out of Mississippi, where Mississippi deliberately passes a law that they know contradicts Roe v. Wade. They know it contradicts Planned Parenthood versus Casey. The case gets appealed up the courts and goes to the U.S. Supreme Court. Dobbs versus Jackson Women's Health Association. And the Supreme Court on January 24th of 2022 issues its decision in Dobbs and officially overturns Roe v. Wade, overturns Planned Parenthood versus Casey. It was a 5-3-1 decision, really, with Justice Roberts not really joining the majority opinion. It
was a 6-3/5-4.
Yeah, so sort of 6-3, sort of 5-4. Justice Alito wrote the opinion, the controlling opinion for the majority. And I would really recommend, by the way, people listening to this show, probably most people listening to this show are not attorneys, but go Google majority opinion Dobbs, D-O-B-B-S, Dobbs. It's really pretty readable. I mean, there are a lot of Supreme Court decisions that I would say, if you're not a lawyer, are really, really hard, well nigh impossible to read. They're not very accessible. They're not very interesting. They're not very well written. There are plenty of Supreme Court decisions that I can barely make heads or tails out of as an actual lawyer. This decision, though, is really something that I think a non-lawyer could read, maybe not understand everything, but could get a lot out of.
Make their way through it.
Yeah, because Alito is a pretty good writer. He's a very clear, straightforward writer. And what Alito does is look at this purported right to abortion and ask, well, is it actually protected by the 14th Amendment? Does the 14th Amendment create this right to an abortion? Does it create rights at all? And one of the things he talks about was, look, if we are going to look at a right that is purportedly created by the 14th Amendment, at the very least, if we're going to concede that it was created by the 14th Amendment, which frankly, I don't know that I want to concede that, but whatever. if we're going to concede that this right was created out of the 14th Amendment, at the very least, we have to determine that this purported right has a long-standing history and tradition as a right protected in American law, that it has to be essential to a scheme of ordered liberty, and that it has to be consistent, deeply consistent with American history and legal tradition. This is what's called the Glucksberg test, and this was a test that the Supreme Court used back in, I believe, 1994, in a case that Glucksberg is a really important Supreme Court case. Basically, it could have been the Roe v. Wade of assisted suicide in America. But instead, the court, it's like, imagine Roe v. Wade if it had been decided correctly. Mm-hmm. That's more or less what Glucksberg was. And basically what the court was saying, Justice Rehnquist, who wrote the Glucksberg decision, was basically just saying, look, we're not creating any new rights unless we can show that it is intrinsic to a scheme of ordered liberty and consistent with American history and legal tradition. And so Alito does this kind of an analysis for the purported right to abortion. Is there a right to abortion that exists consistently in American history and legal tradition? And the conclusion he has to draw is no, there isn't any consistent history or tradition of abortion being any kind of a positive right that someone has. Not in the English common law tradition, which America inherited at the time of its founding, not in early American history. And in fact, what we do find are judicial decisions in the 18th and early 19th century where people were punished in various ways for abortion. What we find is immediately around the time of the enactment of the 14th Amendment, which was purportedly the 14th Amendment is the fountain of this new right to abortion. What we saw instead were a bunch of states before, during, and after the ratification process of the 14th Amendment passing laws to outlaw abortion as if the 14th Amendment was in no way inconsistent with that. One of the most remarkable examples was the state of Ohio, who I believe it was in 1867 or 1868, in the same legislative session that the state legislature of Ohio ratified the 14th Amendment, that same legislature also passed a law heightening various kinds of penalties for abortion. So if you're going to talk about what do the framers of the Constitution think? Well, the people who were voting on adopting the 14th Amendment, in Ohio anyway, at least those very people thought there was no contradiction between the 14th Amendment they were ratifying, on Wednesday and this law to restrict abortion on Friday.
It was certainly not something where they were thinking that inherent in the rights of African American people to not be enslaved is also the rights of women to kill their unborn children.
Exactly, yeah. So after doing this analysis, and that's, I think, the part of his decision, that Justice Alito's decision, that I think makes it so readable and so interesting, because it's really, he's talking about history and American history, and it's actually really interesting. He has this whole section showing all the state laws regulating abortion around this time. Based on that, Justice Alito says the Constitution just does not have anything to say about abortion here. So the Constitution does not mandate any right to abortion. So therefore, states can regulate this as they want. And that is precisely what happened with Dobbs. By the Dobbs decision, now every state can regulate abortion as they want. And for better or for worse, regulate it they have. Now, when we return, Jonathan and I are going to talk about what is the political landscape now. We're 2 years out. Was Dobbs a success? Was it not? That's next on Right to Life Radio. Back with Right to Life Radio. So we've talked about it's the 2-year anniversary of the Dobbs decision, the 2-year anniversary of the overturning of Roe v. Wade, the Supreme Court declaring, no, the Constitution does not mandate that abortion has to be legal in every state for all 9 months of pregnancy for any reason. States can pass their own laws regulating abortion how they want. Now, Jonathan Keller from California Family Council. The political landscape since then with abortion, frankly, has looked pretty crappy.
Yes.
And
that's a good word for it.
And it's a thing of, okay, every state has been allowed to regulate abortion as they want. A number of states have done great things. Texas, Alabama, much of the Southeastern Football Conference.
Yes.
Georgia, a lot
Florida.
of the SEC. The SEC is doing great.
ACC is okay, but yeah, it's
ACC
mostly the SEC
okay,
and ACC.
But the Big Ten is not looking good.
No.
The Pac-12 is
a disaster.
Well, also on a sports football level, the Pac-12 is pretty much completely gone. So we won't even get into the Big East. Now, so a bunch of states have restricted abortion, but a bunch of states have enshrined a legal right to abortion into their state constitutions. The most disastrous of which, I think, was Ohio. Ohio, which has a very Republican state legislature, passed a really good law to limit and restrict abortion, and then the voters of Ohio approved a very broadly worded constitutional amendment to allow some right to abortion, but really it was so broadly worded that they reinstituted Roe v. Wade into their state constitution. So now they have to have legal abortion for all 9 months of pregnancy and for any reason. Now, I'm not feeling great about abortion politically right now. We've got Donald Trump really doing as much as he can to run away from the abortion topic, and John, as best he can.
I got to give you some tea, as the kids say, as my Gen Z staff member Sophia says. I have some tea for you.
Yes, yes.
I was in Washington D.C. earlier this week, and I regret to inform you that I am hearing from closed door sources that there is probably going to be another effort this year to remove some sort of pro-life language from the Republican Party platform in Wisconsin.
Good. Yeah, that is not good. Yeah,
there's just this like absolute fear among the powers that be, the people who are so good at winning elections.
Yeah, well,
they say, "Oh, well, we
can't talk about it." Yeah, well, and it's weird how I think a lot of social conservatives. The dynamics within the Republican Party of, here's the establishment over here, and here's the Trump MAGA people over here. And I think a lot of social conservatives assume, well, the Trump MAGA people are not the establishment, therefore they're going to be more committed to the pro-life cause. And actually, that is not necessarily the case. Whether you are MAGA or not, does not seem your stance on abortion does not seem to necessarily 100% track with that. Mm-hmm. And if anything, there's a lot of Trump MAGA associated people who are now actively running away from the abortion question. Don't want to talk about it, don't want to push for any kind of restrictions on abortion, think it's a total loser electorally, and are almost willing to completely pitch it over the side. So that's a big problem for Republicans. I'll end the show with this. There are some sort of more liberal-leaning pro-lifers who say, well, see how public support for abortion has grown, see how numbers of abortion have grown. Which we can talk about that. We've talked about that a lot, how the numbers of abortion have grown because of the deregulation of the abortion pill. But when you understand, again, what Roe did and what Dobbs did, Roe mandated that every state has to have legal abortion. Mm-hmm. Dobbs said states can not have that. They can regulate abortion as you want. Roe had to be overturned. As a basic question of law, and a basic first step on the road towards ensuring human dignity, we could not sustain having Roe on the books denying a whole class of human beings their rights. And that's how we should remember the anniversary of Dobbs, regardless of the political fallout. That'll do it for Right to Life Radio. See y'all next time on Power Talk.